It could be parent, subsidiary, affiliate, or branch. And only then they would qualify. And then aside from that, there would have to be like some sort of big serious operation that requires some analysis going on abroad, and similar operation in the United States. In these conditions, then the U.S. company would be permitted to transfer the foreign employee into its U.S. company, into the U.S. qualifying organization. There are special requirements for the person, and it's a very different process, and it's again, it requires the petitioner. It's very job and company oriented to see if you're qualified. On the contrary, EB-1A, it's all about you. It's everything you've done and how well you fit into these 10 list criteria. Now, another category, like I mentioned in the beginning, there's another category that permits self-petitioning, is EB-2, employment-based second preference, national interest waiver. It's called in immigration law jargon, it's called NIW. So that one is designed, that one accepts people from having to have job offer or an employer petitioning if their endeavor is in the national interest of the United States. And in order to qualify, one would need to meet 3, and of course we can have a whole separate discussion about that, because that's a very separate criteria, very it's an application of it's a petition of its own, and it has its own special peculiarities and specialties. But in general, the requirements are that the endeavor would be national in scope and of intrinsic merit, and that the person would be well positioned for working in the field, for working in the endeavor, and that the person would be accepted for some reason, valuable reason warranting the waiver. Person would be accepted from having to have an employer and a job offer. In terms of, as an example, sort of practical approach to it, in terms of national in scope, endeavor being national in scope and of intrinsic merit, very, very many fields, most of them would qualify. In fact, there was just a new memo adding a whole list of the fields that could meet the criteria, from business to STEM related fields, which are science, technology, engineering, and math. That would get there, some business fields and others. So in terms of business, it would mean any kind of business that is productive and does, be it a staffing of nurses to the hospitals, be it, equipping, again, hospitals with medical clothing, or be it putting a chain of fitness clubs all over, I don't know, county, state, what have you. Those, all of those setups work. Maybe it's some sort of food, fast food industry providing food on the table. That could also qualify. When we talk about, that's where an intrinsic merit of it, or if it's science, for example, it could be cancer research or some sort of research that does not necessarily gives us a cure from cancer or COVID, but something that advances it. And in that fashion, national in scope for a few years now has been explained, and it does not necessarily involve the geographical component, because some of the discoveries, some of the important things that are happening, they wouldn't necessarily be geographically huge, but they could advance science. They could advance the way we, preserve food, the way we control something, or send information over, things like that, security. All of this would be qualifying. Then with these two, you would move to the next criterion, which is well-positioned. And well-positioned is sort of like a look back for everything you've achieved so far. And I find it very similar. It's very similar to extraordinary ability in a way that just everything that you've done sort of collapses into this one big pot of well-positioned. Because well-positioned means that you could have had prior experience working or doing things. You could have had you could have a new project that you work on based on your prior experience, or you could have your awards or anything, your expertise, you're just top of the field, unmatched, and all of this situation position you really well for the process. So, and the last category, the exception from the job offer requirement, is here's first of all how it comes in. I mentioned earlier that American laws protect American jobs, giving them first preference. Americans should get their job first because it's our country. It is the country that, and actually almost every country in the world has similar regulations. And only if a U.S. employer cannot find a qualifying U.S. worker, only then a foreign national could take that position. So there's a whole test of the U.S. labor market, and if nobody's there, then only then U.S. company can petition a foreign worker. But with national interest waiver, this requirement is waived simply because what somebody does could be of such a value. Maybe it will create jobs for Americans, and the person just simply can't petition them because they own the business, and then the process is just not possible. Or maybe person is part of some sort of research, advancing science, technology, advancing what have you. In that case, it also would be valuable not to interrupt the process. What one cannot use for sure is that the shortage of staffing, the shortage of U.S. workers cannot be used because labor certification process specifically does that, establishes that there's no qualified workers. So that's that. Those are sort of the conceptual differences. Then also EB-1A permits premium processing. National interest waiver does not. So, and therefore it takes much longer. It could take year and a half at the moment. Some cases come a little bit faster, but generally that would be a decent estimate. Then as a second step, once the petition is approved, as I mentioned earlier, there is consular processing for immigrant visas if the foreign national is abroad. But if a person is in the United States, they could file for what is called an adjustment of status. Adjustment of status is an application to basically it's the same as very similar process to immigrant visa that would basically get you a green card, and it's a very procedural process. It takes about a year and a half in general for employment-based categories. And at the end, you typically would get a green card in mail. In some instances, EB-1A permit or EB-2 categories and a national interest waiver permit filing them concurrently. But again, here I would exercise caution and be probably on the conservative side. I'd like to have my petition approved first before I would be filing green card applications, simply because if petition is denied, then it's a domino effect. If petition is denied, then the green card application would also be denied. So having all these considerations, you would weigh. But then in some instances, what if you need to file concurrently? There are situations when things like this come up and you have to analyze them in detail in order to make the right decisions. The form that is used for it is 485, and it requires some analysis and understanding to make sure you maintain status. There are some exceptions to status, but generally, yes, you must have a valid non-immigrant status. Then there could be some conflicts between non-immigrant status because some categories don't permit having immigrant intent, and how to deal with it and navigate. That is all will be very important to understand. Once you get the green card, you could file for an extension for employment-based categories. It's usually issued for 10 years, and it could be extended for which is Form I-90 is used. Form I-90 is also used if you lost your card or it's been mutilated, things like that. Then when Immigration Service accepts your case for processing, it issues Form I-797 with some sort of marcation, I-797A, I-797B, or C, and it would be, depending on the form, it would be a receipt or an approval notice, and etc. The reason why EB-1A program exists is because, and it's a first priority category of workers, meaning these are priority workers. These are most valuable workers, internationally, that could be of value to the United States. In fact, the regulations say of substantial benefit to the United States. In practice, what happens is that once you meet that 3 minimum criteria, and this is how it comes in, once you meet the 3 minimum criteria or that one-time achievement, you have to show that what you do, your endeavor in the United States, will be of substantial benefit to the United States. And it's generally fairly easy established. If it's art, then you're going to be promoting United States positive image or advancing culture in the United States, and those are substantial benefits. If it's science, you will make the United States the top science country in the world, things like that. At the same time, that requirement to be of substantial benefit cross-refers a little bit with national interest waiver, with the field being intrinsic merit and national in scope. So if once in a while that is possible to get a request for evidence like this. So if that happens, I then approach it very carefully, because if you meet all the requirements and then officer wouldn't believe that your endeavor is of substantial merit, it would be very, very sad to get such the case that is so close to being approved. Then so that's the purpose of EB-1A program.